Hey everybody, welcome into the back room. I'm Andy Ostroy. We have former federal prosecutor Andrew Weissmann with us today, fresh on the heels of the breaking news about his sit-down with former special counsel Jack Smith. We'll be talking with Andrew about that and more. But first, thanks for tuning in. We appreciate you listening, and we'd love to hear your comments. So email us at backroomandy@gmail.com and or post on our social media, and we'll read some feedback next time. And if you like the podcast, please rate and review and follow or subscribe, and you'll be notified every time we post a new episode. So Andrew Weissmann is the co-host of the popular podcast Main Justice and is a frequent legal analyst for NBC and MSNBC. He serves on the board of Just Security and writes frequently for it, as well as the New York Times, The Atlantic, and the Washington Post. From 2017 to 2019, Andrew served as a lead prosecutor in Robert Mueller's special counsel's office. His memoir about the Special Counsel investigation, Where Law Ends Inside the Mueller Investigation, was a New York Times bestseller. He is also a professor of practice at New York University and teaches courses in national security and criminal procedure. He also served as the General Counsel for the FBI, and from 2002 to 2005, he served as the deputy and then the director of the Enron Task Force, where he supervised the prosecution of more than 30 individuals in connection with the company's collapse. And he was also a federal prosecutor for 15 years in the Eastern District of New York, where he served as the chief of the criminal division and prosecuted numerous members of the Colombo, Gambino, and Genovese families, including the bosses of the Colombo and Genovese families. Andrew, welcome back into the back room.
Great to be here.
So let's get right into the big news, breaking news, let's call it, front page New York Times news. You recently interviewed former special counsel Jack Smith at the University College London, which has been getting a ton of attention. What are some of the major takeaways for you from that conversation?
I think the biggest takeaway is that it allows you to see Jack Smith for who he is, and you can make your own judgment, and you don't have to rely on a caricature of him from other people. That reminds me a lot of when I was deciding when I left government to do work on television, which I really had not in any way ever expected, and ended up at MSNBC. One of the reasons I did that, actually, I would say the main reason I did it is I thought, you know what, if I'm going to be vilified, I'd like to be vilified for who I am. Like people can see me and like hate me for, for accurate reasons, as opposed to just hearing the noise. And so I was really happy that Jack spoke at UCL. He also spoke at George Mason a little while ago as well. So I just think it's extremely useful. As you may know, I actually think government lawyers, even while they're in government, should be within certain parameters doing more public speaking, and so that they're more like Archibald Cox during the very famous press conference he gave, and people can really get a measure of who they're dealing with, and they can assess them other than seeing them only through what adversaries are saying about them.
Yeah, there was a lot of really insightful things that he said about a number of things, both from the past and that which are taking place right now. So, for example, on all the firings of career prosecutors and FBI agents who worked for him, he was, quote, very concerned about efforts to, quote, demonize these people for political ends, when these are the very sort of people I think we should be celebrating. That's really it, isn't it? Like, these are people that are career prosecutors, career agents. They are dedicating their life, risking their life, and now they are just being demonized, just out of retribution.
So you could relate that to the FBI agents who helped hold people to account for the crimes on January 6th, who are now being viewed as the perpetrators, not the solution. At the end of the discussion I had, I really encourage people to listen to it. Jack Smith got fairly emotional describing one story. Walter Giardina, an FBI agent who Kash Patel wanted to fire, and senior leadership tried to plead with Director Patel to have him hold off. One, he had, not, as we know, not done anything wrong, other than working for Jack Smith, which is not a crime or a fireable offense. But they said, look, even if you're going to fire him, with no cause, don't do it now because his wife of many, many years was dying at the time of cancer. And Jack, you could hear a catch in his voice, rightly. And Kash Patel went ahead and fired him anyway. He also fired the people who tried to plead with him not to do it. And that's an area where, when I'm on air and when I'm talking on my podcast, I'm there for legal analysis, but it's really hard not to step back and say, just as on a human level, who does that? I mean, even if you get through the law point, which is that, let's assume it's legal to do that. Who would do that in that circumstance? What kind of person, while someone's wife or husband, for that matter, is dying of cancer, decides that that's the opportune time to fire them when there's no emergency, there's no external reason to do it at that point in any way, shape, or form? I mean, it really tells you so much about who we're dealing with.
Well, who we're dealing with, I mean, it's an administration where cruelty is the point, and they are just completely devoid of any compassion or empathy, as evidenced by what you just said. Something that I found really striking in his comments when he was talking about Trump's classified documents case and why he brought it to Florida and not D.C., he said, quote, "In terms of the actual case, it was very important to me that we do all of our work by the book." And, what we're talking about here is just blatant, shameless weaponization by Trump and Bondi and Patel of the Department of Justice and the FBI. Yet Jack Smith is talking about how he insisted on doing everything by the book. Merrick Garland, same thing. Went out of his way not to be political. And as a contrast, that's just so fascinating to look at those two different leadership philosophies on how to run DOJ and FBI.
Yeah, absolutely. I mean, his point about, I asked him sort of why the case was brought in Florida, and he said, look, that is the natural place to have brought it. That is where all of the crimes could be charged. That's where all of the events occurred. Essentially, he was saying, I'm not going to engage in judge shopping and forum shopping. And, that's where the law called for it to be brought as, and so obviously he had some discretion to bring it elsewhere. And he was like, I wasn't going to play those games. And that's just the antithesis of how he's been portrayed by so many people.
And he had some interesting comments, too, on the indictments of former FBI Director James Comey and New York State Attorney General Tish James, two situations I want to talk to you about in a moment. But he said nothing like what we see now has ever gone on. There are rules in the department about how to bring a case. Follow those rules. You can't say, I want this outcome. Let me throw out the rules. Again, as a contrast to what we're seeing today, especially with like Lindsay Halligan's appointment down in Virginia, there just seem to be no rules anymore, are there?
Well, the rule is that you do what the president says. So, if the career people think that there's insufficient evidence, that gets ignored. If your own appointee, who's the U.S. attorney in the Eastern District of Virginia, thinks that this case should not be brought because there's insufficient evidence, you get rid of him until you find someone, as a former Southern District of New York prosecutor said, you'll find some fool who's willing to do it. And Lindsay Halligan, who was in office for a New York minute, has now brought the James Comey case, which I think on the face of it is deeply, deeply flawed. And Letitia James's case, where I know less about the merits of the case there and the facts, so I'm not going to really suggest whether it's, a case can be made or not made. But what we do know is that she was targeted. And she seems to me to have a pretty good argument for vindictive and selective prosecution. As I've said about the Comey case, if not here, when? In other words, it seems like if you look in a dictionary for selective prosecution, you're going to see James Comey case. It's hard to imagine that it could be rejected in that case and never have any sort of any legs. I should note Abrego Garcia, the man who was wrongfully and illegally extracted from this country and stashed in a prison in El Salvador. The judge there has found that he has made the initial showing of vindictive prosecution, is entitled to discovery. So we're seeing that when these people are targeted, that judges are indeed pushing back, and there is a body of law that they can rely on. For sure, we're going to see Letitia James and James Comey make those arguments. And I should note, to contrast it to Jack Smith, when those arguments were made, and again, defense lawyers are entitled to make those. They should make those arguments. But when they made them, they were rejected in Jack Smith's case. Even Aileen Cannon rejected it when it was made in her case.
And, another thing that I found interesting in your chat with Smith is at the same time, he seemed very defensive about the accusation that he played politics. He also kind of wrote a lot of that off to just being noise. Like he sort of is straddling both ends there. Like it is something that clearly bothers him from an integrity standpoint, but then kind of brushed it off as, well, that's just all noise. I don't pay attention to, kind of thing.
Yeah, I think the way I understood that was, while you're doing your job, you have to just block that all out. That reminded me a lot of, I've worked on a number of high profile cases. And you do just blot that out. I had friends who would be watching TV or reading the newspapers about stuff, and I find that it's all a big distraction. I went by the director, Robert Mueller, when he was the director of the FBI, was like, look, you're going to be vilified by one side or the other. You're going to be criticized by one side or the other, or both. So you really just have to say to yourself, are you doing the right thing? And make sure you're doing that, and it's grounded in the facts and the law, and then you ignore all the rest.
Mm-hmm. So yesterday, Republicans on the House Judiciary Committee summoned Jack Smith to testify within 2 weeks. I think October 28th is the deadline that he has to appear. This would be a behind closed doors hearing over what they called, quote, partisan and politically motivated prosecutions of Trump. What do you make of this? Is this just for show? It's certainly not legally binding, right? Because it's not a subpoena.
Yeah, I mean, I don't know. I don't know what it is that they think they would learn from him that's not sort of obvious and transparent from the face of the indictments, from the court filings, from the extremely lengthy report that they have issued. And, so it's just stepping back to me. That's the kind of thing where I would, if it was going to happen, I would like to see it not behind closed doors, precisely because I think it's so useful for the public to see Jack Smith, and also to see the people who are either supporting him or attacking him, so they can measure the validity of either the support or the attacks, and against, Jack Smith's demeanor and the substance of his answers. And so the fact that it's behind closed doors makes me suspicious, let's put it that way, or cynical as to what is really going on.
Yeah, well, what's probably really going on is Jim Jordan's fealty to Trump. It's designed for an audience of one. But what's interesting is that even though it's behind closed doors, it does run the risk of backfiring, right? Because what it does is it's still going to be reported on. It's still going to be in the public arena. Your sit down with him will be brought back onto the TV networks. His comments, which contradict their narrative that it was politically motivated prosecutions will be presented yet again. So it's a weird thing to think of, like, why would they want to keep this other than in service to Trump? Why would they want to
Yeah.
keep this alive again for
Well,
another few weeks?
yeah, I mean, I don't know the answer to that. I do think that those risks, the things that you point out, are less when it's behind closed doors. Obviously, we do have the example of James Comey, who testified in 2020 during COVID, who has now been indicted based on an alleged falsehood during that testimony. And so, I'm sure one of the things that anybody who's called in to testify is thinking
Mm,
about is, are you going to take something that is a minor discrepancy or a failure of recollection and blow it up into something that you can be indicted for? Because at least by all appearances, that
mhm.
seems to be what happened in the James Comey case. Again, we don't know all the facts. We'll see what the government has, but based on the fact that none of the career people were recommending going forward, and neither was the sitting U.S. attorney at the time recommending going forward, it suggests that there's a lot of peril in actually testifying, given that what could be totally innocuous gives them a basis to bring a bogus charge.
Well, that presents an interesting scenario because this is a guy who does say he likes to play by the book. Someone would think by the book would mean like, yeah, if I'm summoned, I'll show up. But he's also smart enough to know what you just said, that it could possibly be a trap. Do you think he's going to show up for this, or will it have to go to a subpoena?
I really don't know. I don't know the answer to that. Um, if we were dealing with a normal administration where you normally don't worry about what we just saw with James Comey and potentially with Letitia James as well, then I would think, just speculating here, that he would be like, you don't need to subpoena me. I'm happy to go talk to you about it.
Right.
I don't think it would even happen, though. I don't think he'd be asked to do that because it's sort of obvious what, whatever answers there are I think are largely, if not already, set out in a report. And the claims of selective prosecution have been denied in court. I mean, that has all been litigated. So there's no sort of ground to go back, there's no new ground. It would just be going back over old ground. But I think that the calculus has changed given the
Hmm.
weaponization that's going on.
Yeah. Well, speaking of which, back to Comey now and Letitia James. You know better than most the old adage that a prosecutor can get a grand jury to indict a ham sandwich.
Well,
Our co-
not in DC anymore, because their famous sandwich case, the grand jurors
right.
reported to have said no to that were somebody who,
But he threw the
quote,
sandwich. He wasn't
threw
the
this
ham sandwich. Tish,
right. He
so my question is,
right.
are Tish James and James Comey the ham sandwiches in these
Well,
cases?
you have to, one, we don't know exactly what was presented to the grand jurors. We don't know if they were instructed properly. Remember, in the grand jury, there is no defense lawyer and there's no judge.
Right.
It is just the grand jurors, who are civilians, and the prosecutor and any potential witness. There's nobody else monitoring what's going on. There's no one representing the potential defendant. There's no court there. So we don't know how they were instructed. There is a record of that, and at some point you can imagine the defendants asking at least the court to look at that to see whether it was proper. Um, we so we don't know the facts. We don't, in terms of what was presented. We don't know if they were instructed properly. It's also important to remember that at the grand jury stage, it's not a trial. At a trial, you have to prove your case to the highest standard that we have in the law, beyond a reasonable doubt, and it has to be found unanimously. So all 12 jurors have to find guilt or not guilt. Has to be 12 unanimously either way. In the grand jury, all you need is a bare majority. So 12 out of the 23 grand jurors that sit. And it only is by what's known as probable cause, which there's no precise percentage, but think of it as maybe 20%. So imagine that in the James Comey case, we know that the grand jurors rejected one of the counts. They didn't get a majority. And with respect to the two counts that were voted, it was a vote of 14-9. So what does that tell you about whether they're going to win at trial, absent getting new evidence? Because they weren't able to get 9 jurors to say there was even probable cause. They're going to need to get 12 jurors unanimously to agree that there's proof beyond a reasonable doubt. So that is why, based on what we know so far, this looks like pure weaponization. Nobody going in would say, "Oh, this is a great case," and you're not supposed to, even at the department, the internal rules are you're not supposed to bring a case unless you have a realistic prospect that you can win the case at trial. Not that you can just indict the case. Why indict a case if you know you're going to lose at trial? Well, we know that now in the Trump administration because it inflicts pain, even though you're likely to lose at the end of the day.
Yeah, and this is precisely why we're seeing key prosecutors leave and resign
Exactly.
because they know exactly what you just said.
Yep.
So it's hard to imagine these things not getting tossed at the motion to dismiss phase. Is that how you see these going?
Well, the judge cannot, at a motion to dismiss, weigh the evidence. So that's not where the court can't just say this is too thin. But the court can dismiss it on grounds like selective prosecution. They can dismiss it if Lindsay Halligan, the new U.S. attorney, was improperly appointed. It's sort of a complicated issue, but that's a live issue. And then the other thing that the judge could do is if the trial starts and the government presents its case, if the judge thinks that the end of the government's case that there's insufficient evidence for any rational jury to find proof beyond reasonable doubt, the judge can dismiss it at that point. The other thing, and this is complicated, but I actually think there's a real fatal flaw in the Comey indictment because it doesn't actually allege in the indictment what he precisely said that was false. So for career prosecutors, and I was one, and I've brought false statement cases, you always allege what exactly is it that the person said that you say is false. That is something that is not in the current indictment, and the defense is going to be entitled to it. I mean, if they do not get that from the government, the court is going to order that. That's one where I can say conclusively, it's not speculation. That is fundamentally required. So the only statement that I can see that is apparently one that the government's going to rely on is James Comey saying, "I stand on my earlier testimony." Well, there's nothing literally false about that. That's how are you good if that's the statement, "I stand by my earlier testimony." Even if that earlier testimony is false, that's not the issue. "I stand on it" would be the statement. It is impossible to see how that could be grounds for a false statement charge. And to answer your question, that could be a basis to dismiss the case outright at this stage.
Yeah, I mean, that's why there's so much daylight between the indictment phase and actually getting convictions. It's a long road to prove beyond a reasonable doubt all the things you're talking about when there is seemingly no real there.
But as sure as we are sitting here doing this, Andy, you can be 100% sure that if the judge throws it out or a jury rejects it, that the president's going to say, the judge is tainted, the jury's tainted. I mean, any decision that's adverse to him is because there's corruption in the decision maker. And so, it's sort of from his perspective, this is sort of a win-win. He causes this pain. He has the chilling effect on other people. And even though he's got to know it's going to blow up and he's not going to win, it's like seems so incredibly unlikely that it's going to be a positive outcome. He's going to just chalk it up to more corruption in the system.
Yeah, well, it's political currency for him, which is very important to keep throwing that red meat to the rapacious base. What about the technicality that Lindsay Halligan wasn't properly appointed, and that can end up being grounds for dismissal?
Yeah, well, this is a big issue across the country because the way it's supposed to work is the president gets to nominate United States attorneys, but the Senate has to confirm them. And so that's the process. The president doesn't have unilateral authority. The Senate gets to decide that they should be confirmed or not. And there's a rule about what to do if that confirmation hasn't happened in a certain amount of time. But what the president's been doing is doing like rollover interim appointments so that he never actually has to get Senate confirmation. And there are judges who have said that's improper. So Alina Habba is currently under a court decision that says that she's not the U.S. attorney there. And so it's all working its way through the system in New Jersey and in other places. So this will be yet another place. I think the big picture on that is, I have an idea. Why don't you nominate people who are easily confirmable?
Right.
That is the standard practice for Republican and Democratic administrations. And just to be clear, I've lived through so many of those and worked with so many of those administrations. And you might not agree with their policy choices, but they get through because they're professionals and they're qualified. And this issue of needing to circumvent the Senate doesn't arise because you've picked people who are actually qualified for the job.
Yeah, I've wondered that myself because you can point to people like Pam Bondi who clearly are sycophantic, yet she's qualified, and to your point, sailed through the Senate. I mean, there's no shortage of highly qualified people who will pledge fealty to the king. So why go the route of appointing people who are incompetent, unqualified, and can run aground this way? I don't really understand it myself.
Well, I do think that if you pick somebody who it gives you an extra measure of fealty, I think. You don't want the risk that you're going to have the Eric Sieberts of the world, who was the former U.S. attorney appointed by Trump in the Eastern District of Virginia, who may have been loyalty as a policy matter to the president's goals, again, as a policy matter, but was not willing, according to him, to violate his oath of office, which was to bring a case that was not righteous.
Well, to me, there's a difference between loyalty to an agenda and just absolute loyalty to a king. And
Exactly.
I think you can find, he could find people to serve his needs. The issue about Tish James involves about $18,000 in terms of what she saved, right, by
Yep.
allegedly lying on her mortgage application. $18,000. In your experience, would a case like that ever be brought to indictment this way?
Well, not at a federal level, in my experience. There has to be, for there to be a federal case, there has to be a warranted federal interest. And I worked in New York. I worked in Main Justice at the fraud section. In the fraud section, we were dealing mainly, with tens of millions of dollars, huge cases. In New York, they were smaller, but this level, I'm not, again, if it were true that it happened, I'm not saying that it shouldn't be prosecuted anywhere, but it'd be unlikely to be at a federal level, given just the amount of money being so small. And so, this is one where, again, I really won't say that if there really, really were an intentional crime here, that nobody would bring a case involving $18,000. For a lot of people, that's a lot of money.
Yeah.
To me, it's a lot of money. It's just that to indict the sitting Attorney General of New York, you'd think you'd have something better than that, and bigger than that, and more significant than that. It seems quite small.
Last question. In the absence of a crystal ball, who do you think might be next? John Brennan, John Bolton, Adam Schiff, Bruce Springsteen?
Well, again, I don't know with respect to John Brennan, what the possible ground is, or the possible ground that's within what's called the statute of limitations. There is reporting to suggest that it might be John Bolton. They did do a search of his home and his office. And that's one where let's wait and see what happens. But, if he in fact has highly classified information that he was keeping intentionally, remember, if it's a mistake, that's not a crime. If he was intentionally keeping highly classified information at his home or his office, there are people in jail right now for that. The irony is that is true of our current president.
Exactly.
And he was saying that this was not a righteous prosecution. So, that is to me the big picture. It's like, okay, you're saying that, what happened to you is wrong, it's an abuse, but you're doing it to others.
Big picture in an upside down world. Andrew, as always, great chat. Thanks again.
Thank you so much. Thanks for inviting me.
This episode was produced and edited by me, Andy Ostroy. It was co-produced by Maddie Rosenberg and Jen Hammoud for Radio Free Rhinecliff, with additional editing by Maddie Rosenberg, music by Andrew Hollander, and graphic design by Cricket Langell. And with a special thanks to our sponsor, The Epicurean. Again, thanks for listening. Please rate and review wherever you get your podcasts, and subscribe to the Backroom with Andy Ostroy YouTube channel, where you can watch full videos of our interviews. See you next time.